Welcome to this live segment of the program, The Akuna Matata Lawyer. And this program is spectacular because it is sponsored by Verimas Investment Limited, one of the leading estate companies here in Enugu. If you know that you have interest in buying land, or you are dreaming of buying land, and you don't want to fall into trouble after all your savings, you don't want to fall into buying land that will have problem at the end of the day, especially land that has C of O, then you have to listen good to this program because you're going to gain a lot. Because in this program, we'll be exposing what you need to know about Certificate of Occupancy. I think one of the reasons why the company said I should speak on this topic is because of the inquiries people are making when it comes to land they are selling. Some people have formed the habit of, once the property no get C of O, I know they buy. Some people believe that C of O is all and all. So property will not get C of O. If you buy them, na trouble. Or if you buy them, the property will not does not have a good root of title. So you go see some people. The people will just want to inquire whether property gets C of O. So if the property not get C of O, that is a no-no area for them. And people have been asking, does it mean that lands that don't have C of O are not genuine lands? Or is C of O the best title or the best document that the land should have before you can sell land? Now come closer, because I'll be exposing certain things that you need to know about Certificate of Occupancy. Now, it is a wrong impression for you to think that once a land have a Certificate of Occupancy, that land can never have issue, or that the everything about title of that land is settled. So people will just think that once the C of O is from the government, that is the end of story in that land. That is not true. First of all, what is C of O? C of O, or Certificate of Occupancy, is enshrined in the Land Use Act as a document the government normally issue to people who acquire land from the government. Now, if you have a property that has a C of O, it does not mean that that property can never have problem. If you want to buy a property and the property has a C of O, that does not mean that that property can never have issue. C of O is not the best route of title. It is necessary for you to involve your lawyer from the onset. Whether the land have a C of O or not, the lawyer will help you to find out and dig more into these things I'm going to be exposing to you as we go on. Now, I've told you what C of O is. And the question is, does it mean that a land that does not have a C of O is not a genuine land? The answer is no. This is because the Land Use Act 1978, which is the law that governs how lands are administered in the state, provides for what they call deemed grants. The Land Use Act was promulgated in 1978, but before the promotion of the Land Use Act, we already have how people own land. There are some lands that are already designated as government land. There are lands that individuals own. So the Land Use Act, when it came into force, protected the right of the lands already owned by government. And for those lands that are already owned by the government before the Land Use Act, the government has a right to issue Certificate of Occupancy to individuals to own those lands. So in respect of lands that the government acquired or the government have, land that are already government owned land before the Land Use Act in 1978, the government can actually issue Certificate of Occupancy to individuals to actually occupy the land, develop it, and use it for the purpose for which the government granted the land to them. In such a case, such lands normally don't have issues. But there are some ancestral land, community lands, land that belong to, that is the land of your father, that, before 1978, your father owned this land, and government has not designated that area as an urban area, or government has not acquired such land. The Land Use Act says that the kind of right that exists in such land that the government did not acquire before the Land Use Act, the kind of right that the people who owns that land hold, is what they call deemed grants. That is, it is deemed that the government has granted them that right of occupancy. That's why they call them deemed grants. Now, the Land Use Act provides that all lands in the state are vested on the government, who holds it in trust for the benefit of all. So, because of this, the government has the right to acquire any property anywhere in Nigeria. But before the government can exercise that right, there are conditions that they must satisfy. One is that such acquisition of land, that is private individual land, that is those land that are owned by communities, before the acquisition of such land, government must make sure that the acquisition is for overriding public interests. And overriding public interests can be maybe for hospital, for market, for a purpose that will serve a general purpose. Secondly, the government must pay compensation to the original owners of those land. It is these two conditions that government must satisfy before they can legally acquire individual land or land that have deemed grants. Now, in a situation, as we always see in recent time, where government enters individual land or community lands and begin to issue C of O indiscriminately to people, who are not the owners of this land, without acquiring this land first and foremost for overriding public interest and without paying compensation to the original owners, such certificate of occupancy is unlawful. So if you want to buy a land and you are shown a certificate of occupancy, or you are given a certificate of occupancy in respect of a land which government acquired from individual owners, and the government is giving it to you as an individual, it is wrong. The reason is that government cannot acquire individual property and give it to another individual. It is against the law. So if you have such land, just know that the land has an issue, even though the government has issued you a certificate of occupancy. Because if you enter such land, the original owner can take you to court and contend that the condition for the acquisition, which is that it must be for overriding public purpose and that the compensation has to be paid, were not satisfied by the government before the certificate of occupancy was given. And once these things are proved, of course, the court will nullify that certificate of occupancy and give the original owners of the land the right to ownership of and possession of that particular land. So you can now see that it is not just that the land has a certificate of occupancy, you must still go down to find out how did the government acquire this land. Were the conditions for the acquisition of this land satisfied? I have said it time without number. If the government acquires an individual land and give it to another individual, it is wrong in law. The law says that the government can only acquire individual land for overriding public purpose. That is for a purpose that that will serve the entire public. And secondly, compensation must be paid. So where government even acquire an individual land for public purpose but fail to pay compensation, such acquisition is also unlawful because you've not satisfied that constitutional requirement. Because it's actually the constitution that says that government must acquire land for overriding public interest and then compensation. So you can now see that for a land to be genuine, it does not necessarily need to have a certificate of occupancy. Someone who purchases a property that has a C of O, which government acquired from an individual, without paying compensation from the individual or community, and then give it to another individual, that certificate of occupancy is not as strong as a land you purchase from the individual directly or the community owner directly who owns this deemed grant. So the point we're trying to make here in essence is that certificate of occupancy is not all and all. That a land has a certificate of occupancy does not mean that that land can never have issues. So we must also dig deep to find out how actually was this land acquired. Now, the next issue we are going to look at is issue of revocation, a situation where this time around we are dealing with properties, which are designated as government properties even before the Promotion of Land Use Act. Now, for such properties, I've said earlier that those properties are actually government properties, and government has a right to give such lands to individuals by issuing them certificate of occupancy. We have faced with a situation where most times governments will always stipulate the conditions for such grants in the certificate of occupancy, what they call the terms and conditions. Such terms could be that the person who that allocation is given must develop it at a particular time. Sometimes they give you 1 year, 2 years, 3 years to develop, and maybe you have to fence it. These are conditions, stipulated in those terms of grant. And where you fail to fulfill these terms, government will always revoke the certificate of occupancy and give it to another individual. So what we want to stress here is that it is not in all cases that government has such right to revoke a certificate of occupancy that's given to one individual and give that same land to another individual. In some situations where government has to do that, the law says there are conditions that government must satisfy. These conditions are also expressed and enshrined in the Land Use Act, the same Land Use Act. The condition is that notice must be given to the first person that government allotted that property to. And what the government does most times is that government will publish this notice on the gazette and on newspaper and then proceed to allocate another individual. That is very wrong. The law says that the notice that you must give to the original owner of that land before you can validly allocate that land to another person is personal notice. What the law provided for in the Land Use Act is that you must serve the first allottee, that's the first person that land was allotted to. You must serve him notice of revocation, and this notice must be served personally. So if the government go and publish in a newspaper or in gazette that they are going to revoke so and so land without serving the original allottees with notice of revocation personally, and the government now goes ahead based on such publication and revoke that individual's land and give to another individual, the first allottee of that property has the right to go to court to challenge such revocation, and of course the court will nullify the revocation. So if you want to buy a property that has a C of O, you must make these underlying inquiries. One, this C of O, how was it gotten by the government? Does this land originally belong to the government before 1978? If yes, has it been given to an individual before and then revoked before it is now given to you? If that is the case, was proper notice of revocation, personal service of revocation given to the original allottee before it was now given to you? These are questions that you must clear in the affirmative before you can now accept and say that this allocation government, this land that government is giving you the C of O in respect of, is genuine and will not have problem. On the other hand, if the land happened to be an individual land or community land that the government acquired without paying compensation to the community and for the purpose other than for overriding public purpose, and now the government is giving you such community land with C of O, in respect of such lands, that particular land will definitely have a problem, because by the time you go into develop that place, the original owners of that land, that is the original owners of that property, will definitely interfere with your rights. And when they go to court to challenge the allocation, of course the court will uphold their deemed grant, and the court will the acquisition of that land by the government as null and void. Now that we have exposed these few areas in Certificate of Occupancy, we feel that you will have to be diligent when next you are making inquiries about land. The knowledge you've gotten here will guide you to make the right decisions. I want to tell you, in recent time, there are cases that have come up in court. There is this case of land that is somewhere in Enugu. It happened to be a land that was acquired originally by the government for a marketplace. Some time ago, the government has paid compensation to the original owners of the land and acquired it to build a market, but the market was not forthcoming. So after some years, the government now started to allocate those lands to individuals to come and live in that particular, to come at to individuals to begin to build other things in that particular facility. And of course, the original owners of the community owners of the land challenge the government's action in court, and they are contending that the government does not have such rights to acquire their community property for public purpose and begin to allocate it to private individual. The matters in court, and of course with the expositions you have made, your guess is as good as mine as to what the decision of the court will be in respect of this matter. So do not just be carried away that a land document have a landed property has a certificate of occupancy, and therefore there's no need for you to carry out further research. Like I always said, what we present here, any legal knowledge you pass across here does not obviate the need for you to seek your legal advice from your lawyer, in specific circumstances. Always revert back to your lawyer when you want to buy a property, because your lawyer knows these things I'm exposing to you. You'll be able to do this search, you'll be able to ask these questions, you'll be able to find out what were the conditions fulfilled. He knows all this, and he'll be able to advise you properly on whether that land is a land that you can purchase and will not give you problem in future, or whether it's a land that will give you issues in future. So I thank Verimas Investment Limited, an estate company, for this sponsorship. If you want to buy land in Enugu and you don't want the land to have issues, or you want proper advice from this company, you can actually see their numbers on the screen. You can call the company and they will actually advise you on the propriety of land that you want to buy and whether the land is genuine or not. Thank you so much for watching.